Joel. Is Joel Cannon? Oh, yeah, that's right. All right, so you're Romeo Johnson. And Mr. Johnson's cases are set for trial to begin with jury selection next Monday. Was the announcement?
We're ready, Your Honor. The trial judge provided how the court rules on a certain issue, and that issue being we're going forward with the state decided to put on young officers trial. Felon, we have literally just two pieces of evidence for that trial. The evidence, one of the pieces of evidence, one is a surveillance video that was introduced during the murder trial. The court will call the defendant found not guilty, and that the surveillance video shows what appears to be the defendant possessed of a firearm. The sponsoring witness of that video is out of the country. Will be out of the country for a month. Under Rule 804 of the Texas Rules of Evidence, I believe the state can use the prior testimony of that sponsoring witness because it was subject to cross-examination by defense counsel. We have secured a transcript of.
All right, stop right here. Trial is days away, jury selection is locked in, and now the entire case hinges on one evidentiary ruling. This is where courtroom chess starts. When lawyers say, "We're ready," depending on how the court rules, that's code for everything could collapse or explode in the next few minutes.
That witness's testimony will provide a copy of that transcript to Mr. Wilkerson, and we, if the court will allow us to use the transcript, then there's no need for the team to be ready to proceed with trial. Your Honor, I didn't come prepared to argue that this is the first finding that unavailability unless Mr. Coleman sent me something yesterday.
I don't do anything. There was just recently filed a notice of intent to introduce transcribed testimony.
I did file it with regard to not only the surveillance, but also with regard to the defense office.
Which murder trial was that? Remind me what I'm.
Romeo Johnson murder trial was. The claimant was one of the twin brothers, the Barnes, Robert Barnes.
Yeah,
Brother was in a wheelchair.
Give me just a second.
Yeah,
you know.
Judge, I know you're reading, but Mr. Freeze, or Judge Freeze, did tell me to let you know we're in a trial.
No, take me just a second. I don't know that this would.
My interpretation.
I mean, under 5, so 804A5. Well, first is A is the criteria for being unavailable.
This is a bold move by the state. They want to replay testimony from a murder trial where this defendant was acquitted and use it to prove a totally different charge. Legally possible? Maybe. Emotionally explosive? Absolutely. Should a jury hear evidence tied to a case where the defendant was found not guilty? And here's the tension spike.
So a declarant's considered to be unavailable if. So you've got to get one of those 5 to be unavailable. Then you go to B. So it's not 1, 2, 3, or 4. So 5 would be the only one possibly. It states that is absent from the trial or hearing, and the statement's proponent has not been able by process or other reasonable means to procure the declarant's attendance or testimony.
That is what we're hanging our hat on. My investigator's basis here to testify on the efforts of the state to secure the presence of these sponsors.
Okay.
I represent the court being unable, despite our best efforts, to secure the presence of evidence, given the fact that he's out of the country.
And so, all right, so if we're going to get into that, we'll wait and do it at another time. either lunch or like tomorrow morning or something.
Yes.
Just because I need to set. This is probably. It's only we're down to maybe 2 cases, so I will need to make that decision and number the cases. So let's do this. Because I would need to hear that information. I think I want to look up a little case law just to make sure. So you've got one witness.
No witness at all.
No, one witness that's unavailable.
Yes.
And that witness would be sponsor.
It shows the coalition possessing firearm.
And then the
other piece of evidence would be the defendant's own testimony. For claiming purposes, not suspected. It's the state's portion of the trial.
I just feel like without reading that, and I've never had this come up, where in his own trial, introducing testimony seems to violate the Fifth Amendment to me. Well, I mean, it's almost like you're forcing him to testify by putting on prior. I don't know. Let me look into that.
Party he's admitted from his stand under testimony.
I just need to do some research that I know if it's another party potentially. It talks about when it's a criminal case, what's given as a witness at a trial or hearing of the current or a different proceeding, and is now offered against a party.
I mean, he very well could have asserted his Fifth Amendment right during that trial. He did not.
Okay, let me look into that. You look into that as well. So
Yeah.
804, it looks like we've got 2 things. One is under A with regard to the unavailable
Yes, sir.
witness. The other is under B, which is the former testimony of your client. So let's, I'll give you an opportunity. About how long do you think you guys will be going on?
We anticipate finishing this afternoon, Judge. I can come back on the lunch break, or
No. You're in the middle of the trial. I want you to have to think about this and do that. I will number the cases tomorrow morning. So let's take care of this. Are you available to come? It won't take long. That gives me some time this afternoon to also do a little research.
I've got another case in the 317th, oddly enough, but I think I can kind of delay
if you
that.
can come here first,
Yeah, sure.
it won't take us longer than it'll take 15 minutes. I mean, there's really. I'm assuming your investigator will be quick to testimony as to the unavailability. The other is just legal issues that we all need to just look
I'll
into.
ask for a trade out since I couldn't
Perfect.
stay here.
All right. So head back down there. We'll get you back over here tomorrow morning, 9 o'clock.
All right. Thank
Okay?
you, Judge.
Sounds good. If everybody gets here a little early, we can start early. I'll try to be here early as well. All right. Go back with the bailiff. We'll see you tomorrow. Yes, sir. You'll come back tomorrow, and that way we know what's going on for sure if you're going to trial or not. Yes, sir.
The defense just realized this might be the first time they're hearing the witness is unavailable. Surprise evidence fights this close to trial are a big deal because preparation time is leverage. Would you call this fair play or trial by ambush? Now we're deep in Evidence Rule 804. This is law school exam territory. For former testimony to come in, the state has to prove the witness is truly unavailable and that they made real efforts to secure them. Judges don't rubber stamp this. If that effort falls short, the whole case could wobble.